Hello, everyone. I'm Andrew McKenzie. I'm a lawyer here at Beresford Booth, and I'm here to present to you about statutory warranty deeds in Washington, traps for the unwary. I've previously presented on the eviction moratorium in Seattle and Washington State, and also about statutory disclosures in real estate transactions. So I'm happy to be back here to discuss the exciting topic of warranty deeds. It may seem not particularly exciting to a lot of people until they're actually in a situation where it matters. And a lot of people take for granted that a deed is simply a deed, but in fact, there are multiple types of deeds, and the distinctions between them can make a real big practical difference for you, both as a buyer or as a seller. So we're going to talk about three of the most common kinds of deeds in Washington State. They are the quitclaim deed, the bargain and sale deed, and the statutory warranty deed. Now, in order to explain the difference between these deeds, I'm going to use an imperfect analogy. In my experience, nearly all analogies are imperfect, but imagine that you had a safe and you were going to convey that safe to a buyer. Well, ordinarily, the buyer wants to know what is in the safe that they are buying. It could be valuable gems. It could be completely empty, or it might just be some sentimental paperwork. If you are conveying via a quitclaim deed, it would be like giving the safe to the person and not telling them what's in it. Maybe you don't even know what's in it. Maybe they don't know what's in it. Maybe they've done some investigation from outside sources to determine what's likely in it. But you are not making any promises as to what is in the safe. That would be like giving them a quitclaim deed. All you're doing is relinquishing the control and ownership that you have of the safe and whatever might be in it, but you're not making any promises. A bargain and sale deed, on the other hand, would be kind of like guaranteeing that there are valuable baseball cards in the safe that you own, promising that you haven't damaged the cards, but not making any promises about what damages to the cards others might have caused. So in that scenario, the buyer is taking on some risk. All I know is that this seller is giving me something, but there are some risks that I'm not covered by. In a statutory warranty deed scenario, you're promising that the baseball cards are inside, that you own them, that they aren't impaired by damage, and that you will defend your buyer against impairments or adverse claims. So by statute in Washington, the statutory warranty deed automatically includes 5 warranties. Those warranties are the warranty of ownership or fee title, and sometimes referred to in lawyer circles or crazy circles as the warranty of seisin, because no one ever uses the word seisin, spelled that way anyway. It's an old word referring to the obligation to pay taxes by virtue of your ownership of property. The second warranty is the warranty of the right to convey. We're going to talk about that in a little bit more detail. The warranty that you are conveying free of encumbrances, the warranty against encumbrances, the warranty of quiet possession and enjoyment, and the warranty to defend title. So the warranty of seisin means you really do own the property. I promise that I really do own it. It is a present covenant that is breached the moment it is made if the grantor does not have possession, right of possession, and complete legal title to the property. A grantor has possession if he claims the right to exclusive occupation and no third party opposing his claim is occupying the land. The warranty of seisin, or the warranty of fee title, protects the buyer against breaks in the chain of title. We all know how a break in the chain of title or break in the chain can cause problems. And we're going to talk about that in just a moment with a very short video clip. An ineffective conveyance in the chain of title can make a subsequent deed ineffective to convey title. So if you have a weak link or a broken link in your chain of title, it could look like this for you.
You are the weakest link. Goodbye.
And we certainly don't want that to happen. So the point is that if you are a seller, you need to be sure or highly confident that you actually have good title that you are able to pass. If the person who conveyed title to you did not have good title, then you don't have good title. So it's one reason why it is common for people who have doubtful title to convey via quitclaim deed, because they're not making any promise that you own anything. We're next going to talk about the warranty of the right to convey. So just because you own property does not by itself demonstrate an absolute right to convey it. Sometimes, for example, third parties may have rights to withhold consent to your transfer of the property, even though they do not own title. A typical example could be where someone has an option contract to purchase the property, but has not yet exercised the option, or where someone has been granted a right of first refusal. Right of first refusal is a situation where I might say, okay, if you ever want to sell your property to somebody else, you got to give me a chance to first purchase it on the same terms that your other buyer might be willing to purchase it. That's called a right of first refusal. Your buyer, if you're selling the property, but somebody else has a right of first refusal, is not necessarily going to know about that. You don't want to have a situation where, because you skipped over that right of first refusal, there's now litigation. So the buyer can take some solace in the fact that under a statutory warranty deed, the seller is conveying, promising that they have the right to convey. So if it turns out that someone crawls out of the woodworks later saying, hey, I had an option to purchase, or I had a right of first refusal, well, then at least at minimum, your seller is going to be on the hook for having breached that warranty to you. The third warranty under a statutory warranty deed is the warranty against encumbrances. You are promising that the property is transferred free and clear of liens and encumbrances. Now, most people don't use the word encumbrance in their daily conversations, so I thought it would be helpful to just include a legal definition that's taken from Washington case law about what encumbrances actually are. It's any right to or interest in land which may subsist in third persons to the diminution of the value of the estate of the tenant, but consistent with the passing of the title, and also as a burden upon land depreciative of its value, such as a lien, easement, or servitude, which, though adverse to the interest of the landowner, does not conflict with his conveyance of the land and fee. That's a bunch of legal mumbo jumbo that basically says there are a whole bunch of things that can affect the value of property that give rights to third parties, but those rights don't impair your ability to still transfer title to somebody else. But those rights that third parties have typically are going to run with the land. So your buyer is going to have the same restrictions that you have. For example, if there's an easement on your property, or if there's a mortgage that didn't get paid off and that got recorded in the public records, that's going to follow the land and go to your buyer. So you are promising, hey, these things are paid off unless they are in your deed. So make sure that if there's an agreement, for example, that your buyer is going to be assuming a mortgage or something like that, make sure that you put that in your deed so that they cannot later claim that you breached your warranty against encumbrances. The next warranty under the statutory warranty deed is the warranty of quiet possession and enjoyment. And it's the promise that your grantee, that's the buyer, and his or her heirs and assigns will enjoy the land without interruption by virtue of paramount title. Now, unlike the warranty of seisin and the warranty against encumbrances, The warranty of quiet possession is a future covenant that runs with the land. It is an assurance by the grantor that the buyer shall enjoy the land without interruption by virtue of paramount title, and that they shall not by force of a paramount title be evicted from the land or deprived of its possession. Now, this paramount title language is important to understand what the warranty actually is. If somebody comes to try and adversely possess the land after the closing of the transaction already took place, that's not a breach by the seller of the warranty of quiet possession and enjoyment. The case law holds that the paramount title of the person claiming that they had title to kick you out of part or all of the property, that claim must have existed at the time of the conveyance. So something that comes along later is not going to give rise to liability for the seller. Now, this is a future covenant, as I noted here in this slideshow. That's a critical point for both sellers and buyers to recognize. Here's why. Whenever a claim arises under the law, as a general rule, there's a statute of limitations that starts running. Statute of limitations is a time frame within which an aggrieved party can bring a lawsuit to enforce their right. Okay, so as a general rule, there's a 6-year statute of limitations for breaches of contract. Well, statutory warranty claims, those are breach of contract claims that have a 6-year statute of limitations in Washington. The question becomes, when does that 6 years start to run? So because the warranty of quiet possession and enjoyment is a future covenant, not a present one, it is sometimes the case that that warranty is not breached until long after the closing. If someone brings a claim later, it could be years later, saying, actually, I'm the one who owns this property by adverse possession or whatever other theory, and I hereby demand that you get out and vacate this portion of the property that I own. It is only at that point in the future that you end up getting kicked out, evicted or constructively evicted, that claim against your seller who conveyed the property to you with statutory warranty deed that arises. So one of the lessons there is, if you're a seller and you transfer the property a long time ago, you should not necessarily conclude that any potential claims against you are dead just because they were so long ago. They could be lying dormant and not actually arise until this issue of your buyer's right to possess and occupy the property arises by virtue of a third party making a claim of ownership, or paramount title, as it's called. The fifth warranty under the statutory warranty deed is the warranty to defend title. This is also a future covenant, and it guarantees that no lawful outstanding claim against the property exists. Now, if a buyer wants to bring this claim, they have to prove 3 elements: that a third party has asserted a superior right to the property, that the buyer has tendered defense to the seller, and that the seller has refused the tender. So if you're a buyer and you recently purchased property, or you purchased it maybe years ago, and some third party says, actually, I own part of your property, or I have an easement here, whatever it is. Before you rush off to defend against those claims entirely on your own dime, one of the things that you should consider is, what type of deed did I get when I purchased my property? If you got it by a statutory warranty deed, there's a good chance that your seller may be liable to defend you against the claim being made by that third party. So you need to officially tender that claim to the seller. Tender means to proffer it to them, to offer it to them and say, alert, alert, this is what's happening. I am hereby giving you the opportunity to fulfill your obligation under our contract to defend my title. So if you don't do that, you can't bring this kind of claim against your seller. So it's always critical to do that. We're going to talk about some of the takeaways and conclusions from this presentation. The point of all of this is that the form of your deed matters. It may seem dry, but the language in that deed, the type of deed that you're getting, can have a significant impact on what your rights are post-closing. Buyers should be especially careful when considering purchasing property without a statutory warranty deed. You may think you're getting a great deal on a property when you see that price or you look at the terms, but what kind of deed is that seller actually offering you? Don't necessarily feel like you can rest assured if what you're being offered is a quitclaim deed. If a quitclaim deed is being offered, that puts a higher burden on you as a buyer to conduct more due diligence to assure yourself that you are actually getting what you believe you're getting. Because if it turns out that your seller doesn't actually own the property, you will not own the property either with that deed. That deed won't be worth the paper it's written on. Also, another thing that you can do to protect yourself as a buyer is make sure that in every transaction where you are paying valuable consideration for property, that you get a title insurance policy. That is going to help protect that you do in fact own the property. In some cases, a lot of cases, if you're being offered a quitclaim deed, you can overcome some of the uncertainties and risks associated with that deed by getting a title policy. Also, if there's a chance that boundaries or encroachments may be in dispute, and you've not been provided with a recent survey by your seller or some third party, consider having a survey done yourself before you close or before you commit to buy the property, to make sure that you're not going to be in for surprises later. Also, sellers should carefully consider before just filling out whatever deed you are handed to sign, what kind of warranties you're actually comfortable making. I've seen situations where there is property that has encroachments. The seller has not carefully researched to find out what encroachments there might be on the property. They didn't do any kind of a survey, and just willy-nilly, without a thought, they sign a statutory warranty deed at closing because they don't understand the significance of that versus a quitclaim deed or some other form of deed. And it comes back to bite them in the butt afterwards, because they only realize when it's too late that they are on the hook to their buyer for liability under these various warranties that are imposed under the law for statutory warranty deeds. And as always, whenever you're in a significant real estate transaction where you are wanting to mitigate your own risks, or if you find yourself in a situation where you have purchased property and a claim has come up later, and you thought you were getting something different than what you were paying, than what you wound up with, that's a good time to consult with an experienced real estate lawyer to find out what your rights are, figure out what the best course of action is to either recover for your loss or mitigate the chances that a loss will occur in the future. Thank you for taking the time to listen to this presentation, and we look forward to serving your real estate needs in the future. Thanks.